be seated. Before you call the case, I understand we have a school here with us this afternoon. Thetford?
Yes, sir.
There's Thetford Academy, Thetford High School?
Thetford Academy.
Thetford Academy, what grade?
Grades 10, 11, and 12.
Where's the teacher? Will you stand up? I like to recognize hardworking teachers. What's your name?
My name is Joe Defner.
Joe, thank you for bringing your class here. Thanks very much. Okay. Okay, let's go ahead, please.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled James Ingerson v. Andrew Pallito, Commissioner, Department of Corrections. Docket number 2018-275. Representing the appellant James Ingerson is Daniel McCabe. Representing the appellee Andrew Pallito is David Groff.
Okay, counsel?
Good afternoon, Your Honors.
Good afternoon.
About 8 years ago, Leanne Salls, as a correctional officer, made a conscious decision to begin a sexual relationship with an inmate, James Ingerson. She had a live-in boyfriend on the outside, and she decided she was going to start a relationship on the inside of the prison where she worked. She acted on this plan. This was premeditated, and there's no dispute that she initiated contact with Mr. Ingerson. She had control over him. It was impossible for him to consent. There was no moment when star-crossed lovers were in each other's arms. This ended up with sex in the prison bathroom a number of times over several months. By the parties, or by Ms. Salls' estimate, about 100 times. This started around May of 2011 and continued through September 2011. During this time, there was an investigation into Ms. Salls. It was both DOC and then the Agency of Human Services were looking into this to see what was going on and what was going on, what happened. At no time during this investigation was Ms. Salls removed from supervising Mr. Ingerson.
So at what point do you contend either the agency or the department had sufficient notice that they were obligated to move her into a different unit?
It would be based on the emails from DOC officials.
Right, and I followed the thread, and there's sort of different ones, and they go through time, and I want to know at what point, as I follow through those emails, do you say, aha, by now they should have moved her, they're negligent for not having done so?
I think the cumulative effect, the one that was the most telling, I believe it was C.O. Gauthier. He essentially gives a play-by-play of Mr. Ingerson and Ms. Salls unsupervised in the rec room alone.
So that was about 3 weeks before the softball issue and the ultimate, her suspension.
I think certainly at that point, I think going through the dates of every single email, at a certain point, DOC had more than enough information and more than enough red flags that they should have been separated.
So they had been in an area together, and I think the emails before that had to do with the fact that she was sitting with him often at lunchtime.
She was eating with him. There was talk of when somebody would relieve her post in the echo unit. They would see her overly close to inmates. They would see the lights turning off.
And do you balance this against what her contract for work was? How easily it would have been to say, hey, you're out of here, we're moving you somewhere else?
Well, I think there's some balance. I think that DOC officials misinterpreted what the contract actually said. So that's for another point of this, is whether or not that was straight, simple negligence. I believe it was Superintendent Bovat's deposition where he said, well, she could have, made a union issue, but didn't articulate what that issue was and whether or not she would have been successful. I think balancing an inmate's right to be free from sexual exploitation certainly trumps DOC not dealing with the union grievance.
What role does the lack of candor, to phrase it that way, play in this?
Between Mr. Ingerson and the DOC, or with Ms. Salls?
And the DOC, and Ms. Salls and the DOC?
I think that because of Mr. Ingerson's unique situation, where if he were shipped from the work camp, he would double his sentence. He had a huge amount to lose if he was found to be at fault for anything. Whether or not he could legally be at fault for anything is a different issue.
That doesn't excuse not telling the truth.
I think in certain situations, it explains why somebody doesn't tell the truth. For Ms. Salls, by her own estimation, having sexed them 100 times, it's 500 years in jail and $1.15 million in fines. She certainly had a very good reason not to tell the truth.
Okay, so if I'm understanding you right, then it's okay to not tell the truth, but then sue someone for not discovering what the truth actually was.
I don't think that Mr. Ingerson, in his role as the victim in this case, can be faulted for not being forthright because of his fear that he would be shipped out and double his.
Well, it's not just not being forthright. I mean, he was actually engaging lookouts, right? Other inmates who were looking out for
Sure.
them. So, I mean, he engaged in a process that was designed to ensure that there was no discovery.
His role, because he's the victim, I don't think that comes into play.
Let me turn this question around slightly differently. Rather than evaluating whether he's culpable or blameworthy, the claim here is about whether the state and the state instrumentalities took reasonable care. That's one of the issues, and then we've got the sovereign immunity issue. In evaluating whether they took reasonable steps in response to the information they have, isn't it relevant that they tried to conduct an investigation, in fact, got outside interviewers to interview him in a context in which he would be protected from any adverse consequences from that interview? They did the same with her, and regardless of whether we find him blameworthy, the fact is they investigated as much as they could, and they didn't come up with any evidence to support disciplinary action at that time or further action against her.
I think interviewing two people that have a very good motive not to be truthful shouldn't be an exhaustive investigation.
So what other acts or omissions by the department support your negligent supervision claim?
Failing to separate them physically. I mean, all they needed to do was switch her post.
So aren't they setting themselves up if they interview both of them? They both lie, say nothing has ever happened before, and then they tell her, we're switching your post, which may or may not be in violation of her employment contract.
I think at the very least, they need to figure out whether or not it would be a violation of the union contract. You know, part of our briefing was that it wouldn't have been a violation, and they would have been within their grounds to do so.
So it's all isn't it all boiling down to their discretion? They interviewed, they found what they found, they decided for whatever reason, you said they did consider the employment contract in some way, and then decided not to move her. Isn't that exactly what we're talking about, discretionary decisions
I think at a
that
certain,
they entered into?
I'm sorry.
Go ahead.
I think at a certain point, preventing sexual assault needs to take some precedent over not really considering a union contract correctly. I think you can consider something, but you need to do it correctly. Otherwise,
Well, it would have been a problem if they said, oh yeah, we know there were these sexual assaults going on, but because of the union contract, we're not gonna make waves. That's a whole different story, right?
it is. I mean, part of the issue is how, if there's any sort of inference drawn from these multiple staff reports, how far was this going? And whether they say, well, we've got, 10 staff members saying these two are overly close. This is crossing the line. We have to start an investigation. And then to simply say, well, she said it wasn't. And then that's the end of it.
Well, that wasn't quite the end of it, though. They
He
put a
said
camera up,
There
and
wasn't anything either.
there was a camera installed,
Well, no, so.
directed to the
Well,
crotch
and-
camera.
Yeah, the crotch cam. I apologize. It's silly. I mean, you've got these, that sort of gets to the ministerial duties. They're doing an investigation. They know there's a blind spot right where the guard sits. They can see somebody off camera. They decide to move the camera. Then they just move the camera wrong. So they know they need to see something that they're not seeing. They move the camera, and they do it so poorly that it creates a firestorm of other union issues. And then rather than fix it and put it the right way it should be so they can actually monitor the bathroom and monitor the guard post, they just give up. So they've identified the issue, they've tried to remedy the issue, and then it got too hard, and they stopped. And that seems to be the theme for DOC is they sort of do stuff, it just doesn't get to the level where they figure it out.
I realize this isn't directly in front of us, but I am curious as I spin this out. If you succeed and the case goes back and is tried, what's your theory of damages in this case?
From the point, Mr. Ingerson did not initiate this at all. He thought he was being set up. She initiates a sexual contact with him. He's immediately very fearful. This gets more and more involved. They continue to have sex in the bathroom over a period of months, and they conceive a child. The state's briefing sort of glazes over this 2-year period where Mr. Ingerson missed the birth of his child, had no contact with his child, had very minimal contact with Miss Salls. I mean, the conception of a child and not being part of that child's life is an element of our damages.
That's your emotional pain and suffering claim?
I think it's very fair to say that if you have a child you've never met and you know it's out there, I mean, the side issue that wasn't briefed was that Ms. Salls was still living with her boyfriend on the outside.
So it's sort of a wrongful birth claim then, because he didn't see his child because he was in prison, not,
He didn't see his child because Leanne Salls couldn't bring the child in.
okay. And I didn't mean to take you off
No.
the main issue, I just
No.
was curious about that, it's helpful to hear.
I mean, the background is that Leanne Salls was in a fairly abusive relationship. His son was being brought up in that relationship. He knew about it and could do nothing about it. He doesn't, he loves his child, but he wasn't planning to have a child.
So your claim for emotional damages here on your complaint, it's the failure of his inability to parent this child he conceived.
That's part of it.
And the rest of it is what?
The stress he felt while this relationship is ongoing on the inside, he has no idea what's happening. He has no ability to stop the relationship. He has no ability to consent.
Wait, he's having sex with somebody 100 times and he doesn't know what's going on?
He doesn't know what's going to happen and whether or not he's going to be shipped out and have 6 more years in jail.
Then why is he bribing people to stay on lookout for him with cigarettes?
I would suspect because it's better to not figure out if he's going to do more time.
And you acknowledge there were appropriate postings and procedures at DOC which told inmates who might be in similar circumstances how to report this?
As far as the posters on the walls,
Yeah.
I have no reason to doubt that. I mean, I didn't tour the facility.
So he certainly then had noticed that if he thought he was in a relationship that violated policy or law, he could have and should have brought that to someone's
It's my understanding there's hotlines and there's phones that it could be brought up. I think the issue is whether or not, so for him, if he reported this, says, this guard is exploiting me right now, and she says, no, I'm not, or in fact, he approached me and he made a pass at me, that event and him getting the disciplinary action from that could double his sentence. So it's not just that if he makes a report and it's not believed that things just go back to the status quo, he could in fact have more years to serve. And I think that's part of our damages claims. Well, that fear that this relationship is out of control and that he could do a lot more time because of it. I didn't mean to go off on a tangent
No, that's fine.
question, but no, the posters were up. We're not disputing that. Part of this case also involves DOC not creating regulations. In 2003, we had this policy that says we're going to establish some guidelines and some procedures of how to investigate these types of events. But then for 8 years, it never happens. And now DOC uses the lack of procedures to say that we did things correctly. Or
They have a duty to expound on their regulations, like they said they were going to? Was there some duty created?
I believe that, can I finish this one then? I think there's been federal case law talking about when agency inaction has gone too long. I think that's the track analysis of 8 years on an issue that involves sort of fundamental personal rights is too long.
Okay, thank you. You're set? Okay, thank you, counsel.
Thank you, Your Honors. Good afternoon.
Good afternoon.
I'm David Groff from the Attorney General's Office. I represent the state. Well, let me start off by saying Ms. Salls committed a crime. Ms. Salls faced prosecution for that crime and was convicted of that crime. So let's start there. Ms. Salls was the bad actor in this case, and she was prosecuted. But let me also say that despite the shocking details of this case, really this case presents a pretty straightforward application of the state's retention of immunity under the discretionary function exception to the Tort Claims Act. As your honors, I'm sure, are fully aware, that provision retains immunity when the state has discretion with respect to how to engage in the conduct at issue. There's two prongs to the test. The first prong asks whether a statute or regulation prescribes a specific manner or method to carry out the duty in question.
So their claim is, though, as counsel just spoke, that you were obligated to develop regulations that would have removed any potential for discretion, or at least would have reduced it. And that's part of their claim. What's your position about that?
Sure. Well, there's three main problems with that argument. Number one, essentially what that argument boils down to is the claim that the adoption of policy doesn't involve discretion, when in fact the exact opposite is true. The adoption of guidelines and policies is the core of what the discretionary function is about. So to base a claim on not adopting further policies, refinements of the policy that was in place, is really at the heart of what the discretionary function is intended to protect. That is, judgments about all of these issues that the court has discussed with my colleague. When should they take action? How much evidence counts? All of that stuff is the heart of the discretion.
Can we explore then the scope of this sovereign immunity?
Sure.
And change the facts, and we're going to have a guard raping an inmate at gunpoint repeatedly with the knowledge not only of other guards, but credible reports to the supervisors saying this is happening. Yes. Is it your position that in that circumstance, complete inaction by the supervisors in an exercise of their discretion as to whether or not to investigate and how is cloaked by sovereign immunity and couldn't support any sort of negligent supervision claim?
No, Justice Robinson, no. Because policy 126, which was in place at the time and is in the record, required that any claim of sexual assault be investigated, be referred to police, and that in all but the most rare circumstances result in the dismissal of the officer. That policy was in place at the time this event occurred. And let me step back and say, it's a little odd to me the suggestion that the department has attempted to avoid liability by not adopting a further policy. The only policy in place requiring an investigation came from the department. The department imposed that obligation on itself. And the only complaint is that they didn't then refine that through further directive.
You don't think the department would have an obligation in the absence of that policy to investigate credible reports of guard on inmate assaults?
Well, no, I think that duty would exist. There's a statute that requires that the department take proper measures to protect the safety of inmates. Now, the issue of whether in the absence of any policy the discretionary function immunity would apply is, I think, a more difficult one. I think in a case like the one you described, it would be hard put to argue that specific of a threat and knowledge didn't trigger a duty to take some positive action.
So once you have a duty to take some positive action that may not be cloaked with sovereign immunity, are you then subject to legal responsibility for taking those steps negligently? In other words, okay, we're going to investigate, but basically doing a really bad investigation.
Well, I think that what the exception would require is that any ministerial steps, any specific steps that are required to be taken, have to be taken. And that if they're taken negligently, then there's a possible claim. I think, there's two cases decided in the DCF context and the SRS context that I think make the point that I'm trying to make. It's Sabia on the one hand and Earl on the other hand. Both cases where allegations of sexual abuse of a child were reported to DCF. In both cases, there's a statute that requires an investigation. In the first case, DCF did nothing. That case, the state is liable. In the second case, DCF took action, investigated, but the plaintiff thought they did a bad job and thought that they came to the wrong conclusion. That case, the state has immunity. So I think that's the situation here. This isn't a case like the one you posited where the department has notice of a sexual assault and does nothing. That's not this case. This is a case where the department had notice of what they call boundary violations, talking too much, spending too much time together, and investigated. And in that situation, I think that the immunity applies. The second problem with the relying on, if I answered your question, with relying on the policy or the failure to adopt a further policy, is that it relies on pure speculation about what that policy would have required. What evidence is there in the record that if the department had adopted some policy, some different result would have come about? In fact, the eventual directive that was adopted in 2014 wouldn't have required anything different be done in this case. That directive requires that separation issues be considered when a credible report of sexual abuse has been made. That didn't happen in this case until September, after which Ms. Salls had no contact with the plaintiff. So the idea that adopting a policy would have resulted in some different result, there's no evidence from the plaintiff about what a reasonable policy would have entailed. The only evidence in this case is that the department took reasonable steps to train its officers. Ms. Salls admittedly was trained on exactly these issues, both at the academy and on a recurring basis. Mr. Ingerson acknowledged that he was apprised of his rights and how to report allegations of misconduct by staff. There's a signed receipt from him in the record acknowledging that receipt just a couple of years before these incidents happened. So I think that, the evidence in this case.
What about, though, this period between the report? That seemed like a pretty damning report. They're in the rec room or whatever the facility is. Nobody else is in there. They're the last people there. They sort of come out 10 minutes apart, close down at the end of the night. Wouldn't that be enough notice for the department to say, okay, we need to, while we continue to investigate, we need to make sure that this CO isn't supervising this inmate anymore?
You could make that argument. I think the whole point is, though, that that's a judgment call. How much of this evidence got to be to the tipping point? The department decided it was the point when someone reported sexual touching. But the point of the immunity is that is a judgment call. We can second guess it now. It's interesting to note that according to Ms. Salls, all of the sexual conduct took place not in their rec room, somewhere else. Nevertheless, I can see why someone might consider that to be a more substantive allegation than others. It's still not an allegation of sexual conduct, so that's a judgment call. I guess I'd like to also touch on the point about, aside from the immunity issue, could a reasonable jury determine, and under the facts of this case, that if there was a duty and there was no immunity, the department breached that duty? And I think the point was made earlier that Mr. Ingerson just simply cannot complain about an investigation's failure to uncover conduct while simultaneously admitting to hiding that conduct and to lying about that conduct during an investigation. You can't simultaneously set up hurdles to the department and then complain that the hurdles weren't cleared.
Are you suggesting that that's an intervening cause if there was negligence here?
It could be considered an intervening cause, or it could be considered just evidence that there was no breach. The department tried to investigate. The investigation was obstructed. In the trial court, we argued it alternatively as a failure to show breach or as comparative negligence or some theory. The point is, you can't hide conduct from the state and then complain that the state didn't find it. That's just unfair, the obligation of the state. Unless there's any more questions.
Okay, thank you. Does the appellant have time?
Appellant has 1 minute and 45 seconds remaining.
Okay.
Just to touch on the comparative argument, this case was brought against two defendants. There can be essentially no dispute that Ms. Salls was the actor, and between Mr. Ingerson, DOC, and Ms. Salls, collectively, the defendants had far more than 50% at fault. Whether that gets remanded and it gets parsed out further, I don't think it makes much of a difference. If there's 1% negligence on DOC, they become joint tortfeasors. So whether or not the comparative, I think that's irrelevant to this analysis. It's also not what the trial court made its decision on. Touching briefly on ministerial duties and referencing the Kenny state, where the Vermont State Police went to the wrong house for a welfare check, make the same parallel between the moving the cameras incorrectly. This is a very ministerial thing. One person told them to move the cameras. They just did it wrong. We look at that as just very basic negligence. We don't need to have a procedure identifying every single immediate step. You don't have to move the cameras correctly.
Of course, isn't it speculation that if they had moved the cameras correctly, they would have discovered something?
I think the fact that DOC wanted to see more in a very specific area could lead to the inference that there was something in that area to see.
Of course, the two folks that were going to be filmed might know the camera's been moved and not do it in that area.
Except that if this is all in the bathroom and they had the bathroom door, that's it. I don't have a picture of exactly how the echo unit's laid out, but if there's one main spot this is happening and it's close to where the camera is, they could see it. Thank you.
Okay, thank you very much.
The next hearing for the court will follow immediately.